Okay, in this video I'm going to take a look at property orders in judicial separation or divorce cases. These types of orders are also called ancillary orders. Ancillary orders will cover a range of different orders a court can make in a divorce or in a judicial separation proceeding. But this particular video, we're just going to take a look at the property situation. The first thing you need to understand is that it relates to the family home. The Family Home Protection Act 1976 says that a family home is is primarily a dwelling in which a married couple ordinarily reside. So that is the definition of a family home. Then there is property adjustment orders and there's preliminary orders. A preliminary order is an order that a court can make in a divorce or separation, judicial separation situation in respect of the family home, which predate the hearing of the legal proceedings. So this would predate the actual hearing itself for the divorce or the judicial separation. It's a preliminary order. After that then you have the regular property adjustment order, and the court, be it the circuit court or high court, has a very wide range of discretion. Firstly, the property can be transferred from one spouse to another, or to any dependent family member or to another person for the benefit of such a family member. 2. The court can reduce or extinguish any interest that a spouse has in the property under a settlement. 3. The settlement of the property for the benefit of either spouse or dependent family member is possible by way of a property adjustment order. And 4. The court can direct an order which varies a previously agreed settlement of property. So the court has a wide degree of discretion in terms of varying property adjustment orders. And to all intents and purposes, you could say that a court can do practically what they like in terms of making a property adjustment order in a judicial separation or divorce situation. However, the question of remarriage means that no order can be made in favour of a spouse who remarries, and an application for a property adjustment order must be made during the lifetime of the other spouse. So the other spouse cannot have passed away, and the spouse that is looking for a property adjustment order cannot have remarried. The courts can also order the sale of the family home, but cannot do so if one of the spouses remarries and is living in the home with his or her new spouse. Property adjustment orders can actually be made in respect of all types of property, not just the family home, and no property adjustment order can be made in respect of the family home which cannot be varied by the court. So that makes the point that I was making just now. The court has a huge discretion when it comes to making property adjustment orders, and will do so in the particular circumstances, having looked at the affidavits of means and the means of the parties and so on and so forth. In relation then to separation agreements, in the case of a divorce, the court must take into account the terms of any separation agreement between the parties. However, the court can set aside such terms and ensure proper provision in the eyes of the court before granting a divorce. So court will have regard to separation agreement and the terms of it, but will not be completely bound or dictated to by those terms. There appears then as well, on foot of case law that we've seen, there appears to be no limit on the number of times a spouse can seek a property adjustment order, save that any such order cannot be granted in favour of a spouse who has remarried. So this is the notion again of no clean break divorce. In other words, one of the spouses can go back for another bite at the cherry. Hope you find this video useful. If you do, I'd appreciate if you gave it the thumbs up down below. And my contact details are on the screen there. Thanks for watching.